think it's our last case. This is People of the State of Michigan versus Jack Daniel Schoenbeck. This is file number 25-14168FH. Appearances from counsel, please.
Lisa Gold for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Schoenbeck.
Schoenbeck. I apologize.
I butcher it all the time. I apologize as well to both of you. I'm presenting a signed advice of rights. I realize now I may have neglected to inform Ms. Dell of the same, but.
All right. We are here today for a final pretrial conference. I did not yet have the opportunity to speak with counsel, but I have a feeling we're getting to a plea. Ms. Dolan?
The offer I made to defense is if the defendant were to plead guilty to count 1, we would dismiss count 2 with restitution in the amount of $900 to be paid, and dismiss counts 3 on the habitual offender notice.
That comports with my understanding, Your Honor.
All right, so I'm just going to state that out loud again. The defendant's going to plead guilty to count 1, larceny from a motor vehicle. The people will dismiss count 2, malicious destruction of personal property, and count 3, larceny less than $200, as well as the habitual offender third. Is that correct? In addition, I know the restitution.
Yes, Your Honor.
Indeed.
Mr. Harrison, does that comport with your understanding?
It does, Your Honor.
All right, good. All right, Mr. Schoenbeck, please raise your right hand to the best that you can. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. Ms. Schoenbeck, you are charged on a felony information day with 3 counts. Count 1 is a charge of larceny from a motor vehicle. That is a felony punishable by up to 5 years and or up to $10,000. I'm told you're going to plead guilty to that count. Now, there is a third habitual felony enhancement that could increase that maximum punishment from up to 5 years to up to 10 years within the discretion of the court. However, that enhancement will be dismissed if you plead guilty to count 1. Counts 2 and 3 will also be dismissed. Count 2 is a charge of malicious destruction of personal property having a value of $200 or more, but less than $1,000. That's a misdemeanor punishable by up to 1 year and or up to $2,000, or 3 times the amount of the destruction of the property, whichever is greater. That count will be dismissed. Count 3 is a charge of larceny and a value less than $200, and that is a misdemeanor punishable by up to 93 days and or $500 in fines and costs, or 3 times the value of the property, whichever is greater. That count will also be dismissed. Is that what you understood you were doing today, sir?
Yes. Yes.
Now, there's another term, and that is that you are going to agree at sentencing that the court can include a restitution amount, which means money that you would pay to the victim, and that's $900. Is that also what you understood?
Yes, sir.
All right, thank you. Now, by entering a plea of guilty, if I accept that plea, you're not going to have a trial. Does that make sense?
Yes, sir.
Now, I'm holding up this piece of paper that Mr. Harrison provides me. At the top, it says advice of rights. At the bottom, it appears to have your signature. Is that your signature?
Yes, Your Honor.
Did you read through these rights before signing?
Yes, sir.
And do you understand what you read?
Yes, sir.
And even more importantly, do you understand that if you enter a plea of guilty today and I accept that plea, you will be forever waiving these rights as they apply to just this particular case?
Yes, sir.
Also, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me now. Other than the terms of the agreement, have there been any other threats, promises to arrest, coercion, or anything to get you to plead guilty?
No, Your Honor.
Are you making, therefore, the choice of your own free will?
Yes, sir.
Now, Mr. Harrison's probably talked to you about potential sentencing, maybe talked to you about the sentencing guidelines, things like that. Maybe applied his breadth of experience of being in this courtroom and trying to give you ideas to what this guy here would do. Has he made any promises to you?
No, Your Honor.
And has he been able to talk to you about it, answer any of your questions, talk to you about the case, explain your rights and things like that?
Yes, Your Honor.
Are you satisfied with his advice?
Yes.
And do you believe that entering this plea today is in your best interest?
Yes, Your Honor.
Oh. As to count 1, larceny from a motor vehicle, how do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turning your attention to November 18th of 2025 here in the city of Cadillac in Wexford County. Tell me about it. Where was this vehicle?
It was at factory, I believe, in Michigan Rubber, I think, or something
Okay.
like that.
And were you working there? Or were you?
No, my girlfriend was working
Right. And so what happened? Did you see this car?
there. Yeah, I knew it was there, and I went to the car and opened the door and took a backpack that had stuff in it.
All right. So you didn't have the right to open that vehicle?
No, I did not.
Did you know whose it was?
Yeah, I knew who it was, yeah.
Okay. And so when you opened it, you took that backpack. Was the owner of the vehicle there?
She was working. She didn't know I was there.
Right. So she didn't know you were there at the car, entering the car, taking the bag. So you didn't have permission to enter the car or permission to take the bag.
No, sir.
And inside that backpack, it looks like there was a computer, a laptop or something?
Yes, sir.
Okay, all right, thank you. And when you took it, did you have the intent to keep it, not return it back to her? So just tell me, what was your intent for doing it?
Well, my intent was I was looking for items of mine in there, but I knew it was her stuff. And,
Okay.
I would have given it back, but no, at the time I was keeping it.
Ms. Dahl, do you believe that defendant has provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with 6.302?
Yes, Your Honor.
Mr. Harrison, how about you?
I'm satisfied as to all three of those points.
Court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for count one. Therefore, the defendant is found guilty of count one, counts 2 and 3, and the enhancement will be dismissed at the time of sentencing. We should be back here about 4 to 5 weeks on a Monday morning for sentencing. You're going to get a packet here that's being prepared by the court. It'll be given to the bailiff. You're going to open it up, fill out the information that it asks for, and turn it back in. You'll also be subject to an interview with an agent from the Department of Corrections, as they're going to prepare a pre-sentence investigation report that will describe to the court the criminal offense, the original charges, what happened, statements, information you make to provide, recommendations as to sentencing, scoring the guidelines, which neither one of those are mandatory, as well as a report on your prior criminal history, as well as your performance on the bond, probation, or parole. You understand?
Yes, Your Honor.
So you're going to get that package, complete it, turn it in. You'll be subject to an interview with an agent from that office. You have the right to have Mr. Harrison present during that interview. And third, Mr. Harrison will meet with you prior to coming back to court, generally about 10 days to 2 weeks prior to sentencing. He needs to go over that report with you, as each side has the right to come back to the court and request corrections or amendments to the report. Do you understand, sir?
Yes, Your Honor.
All right. Anything else, Mr. Harrison?
Not at this time, Your Honor.
Thank you. Ms. Dahl, anything further?
Your Honor, if I may have just a moment.
You may.
Nothing further, Your Honor.
Thank you. Anything else, Mr. Harrison?
Nothing further, Your Honor.
Thank you. We are adjourned.
Thank you.
Here in the courtroom, joining me at the defense table this morning is Mr. Timothy James Miller, and also we have Miss Lindsay Simmons. She is the probation officer handling the case today. We are here today, Mr. Miller, for what's called a show cause hearing. It's also really kind of like an arraignment where I need to tell you what the allegation is, what your rights are, your possible consequences, and then see how you wish to respond. There is again a request and summons for a probation violation filed in this case file. And it alleges a single count of a probation violation. That count alleges that you have, you are required to still pay $1,222.60 on your outstanding court ordered assessments, and that your last payment was made on December 16th of 2025 for $20, and your discharge date is currently set for March 11th, 2026. Have there been any other probation violations on this particular file?
On this file, yes, Your Honor.
Tell me about, what
We had,
did work?
back in July 11th of 24, Mr. Miller was walking down the road, drinking, and then he failed to report, so he was absconded for a couple weeks. He was sanctioned with jail and scram on that one. There was another incident in February of 25. I want to say that was consuming alcohol as well, but we released him same day and put him back on scram. We had one, it was just one dirty drop.
So how many technicals are those? Were those?
Those were technicals, yes, Your Honor.
Yeah, all right.
And then the dirty drop was a warning and then referral to treatment. We didn't.
So we have at least 3 priors.
Yes.
Thank you.
Yep.
One second. You have the right to challenge a single allegation at a contested hearing. At that hearing, the prosecutor would have the burden of proof by a preponderance of the evidence. You have the right to be represented by an attorney at that hearing, and if you cannot afford one, an attorney could be appointed to assist you, or would be appointed to assist you at no expense. You also have the right to review the evidence presented against you, question or cross-examine any witnesses presented against you, as well as the right to present witnesses, evidence, or testimony, or the right to remain silent and not have that silence used against you if you so chose. If you're found to be in violation of your probation, you'll be resentenced on your original offense. In this case, you were originally convicted of possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Now, that conversation I had with Ms. Simmons is important because it tells me that we have 3 prior technical violations. This could be the 4th. And with a 4th technical violation, the court is no longer limited to a sliding scale of 15 days, 30 days, or 45 days for your 1st, 2nd, or 3rd technical. However, whether or not the court can give you an additional jail would actually require proof of failure to pay when you have the ability to pay. That's always up to the prosecutor about proving. The court can also extend your probation to provide more time to pay it. If somebody doesn't pay, then the court later on can always call a person in periodically. I do that often. If people come in and I charge them with, the clerk's office brings it in and we charge them with contempt for failing to comply with court order. Then I normally issue a bond. Bond's normally about $500 to $1,000, which of course, once the person pays it, that gets applied to the fines and costs. So I've kind of gone through a lot there. The first question is do you intend to hire an attorney, or do you wish to have the court appoint an attorney, or do you not want an attorney?
I don't think I need to, yes.
All right. Now, when you say that, it's perfectly fine, but then I have to go over to this old pink sheet over here. Some more questions.
Okay, with appointed.
What's that?
Just go with an appointed?
It doesn't matter.
Yeah, I think we should take that route.
Oh, okay. I don't mind reading the pink sheet. Put it up here. I'm just saying. I don't care. All right, Mr. Miller. The court therefore will refer the matter to the Wexford Misaki Public Defender Program for the appointment of an attorney. The court will enter therefore a not guilty plea. Are you on probation or parole anywhere else? Good. This case now will be set for a formal hearing. Informal hearing. At that informal hearing, you'll be here. Ms. Simmons hopefully will be here, a prosecutor, and then the defense attorney will be here. And then they'll tell me what we're doing. Their options will be that there'll be a plea, a dismissal, or there'll be a formal hearing. And the formal hearing is really just calling the clerk to say what is or isn't in the still numbers on the account. So anyways, but we can figure out what happens, and maybe you're able to make some payment arrangements and so forth. Good. Any questions at this time?
Not at all.
Any objection to just the PR bond?
Oh, not at all. No.
Good, good. You're released on your own personal recognizance. Make sure you still comply with your terms and conditions of probation. Just as a reminder, your probation discharge date can be pushed out, not only if you're found to be in violation of probation, but until this is resolved. So, but it looks like you got what? Well, oh, we're already into February. Yeah, so anyways, that discharge date, it might be set for a day, but it'll get pushed out until this allows. Any questions of me, Mr. Miller?
Not at all.
All right, thank you very much.
Thank you.
We'll see you in a couple.
Take care.